Directly to the people of Jackson County. Our community is grieving the tremendous loss of Nolan Wells, who is loved and treasured by everyone. Nolan's family deserves answers, and our community deserves answers. Every death in the county, except those of natural causes and non-criminal car wrecks, are presented to your grand jury. Many people don't know that. We have handled death investigations in this manner my entire career. Nolan's case is being handled the same way, with the same care and the same commitment to the truth that we handle all death investigations. I understand the public's urgency to know what happened to Nolan, but we are not taking time for time's sake. We are taking the time required to complete the work this investigation demands.
There are 3 words sitting inside a sealed file in Jackson County that could end this entire case by tomorrow morning. The district attorney has read every page of it. She has never once said them out loud. This is true crime evidence. Subscribe and turn on notifications so you don't miss stories like this one. For 3 weeks after Nolan Wells' body was recovered off Horn Island, District Attorney Angela Mears-Marath said absolutely nothing publicly. No statement. No press conference. No acknowledgement that a family was waiting, that protesters were in the streets, that a national audience had started asking why the silence was lasting this long. The Justice for Nolan movement kept growing during that stretch, not shrinking, and the silence itself became its own headline. Then, on July 23rd, she released a video addressed to the people of Jackson County. If you were hoping for clarity, an actual update on what investigators had actually found, what arrived instead was something far more revealing than a straightforward answer ever could have been. Because in law, what a prosecutor chooses not to say can carry exactly as much weight as what she does. Here's what she confirmed. Every agency involved in this case, including the sheriff's office, has been ordered to stop making public statements entirely. Under Mississippi's rules of professional conduct, prosecutors can't discuss evidence, witness interviews, or investigative findings while a grand jury proceeding is pending. It's a legal gag order, and it's total. When a reporter caught Sheriff Ledbetter outside his office this week and asked him directly about the case, his entire on-record answer was 3 words: actively under investigation. That's the legal ceiling right now, for him and for everyone else attached to this case, regardless of how many questions keep piling up outside it. Marath herself explained the silence in her own words. The restraint in communicating facts and evidence, she said, is not an effort to keep the truth from the public. It's an effort to protect the integrity of the investigation and the grand jury proceeding. She added that sacrificing that integrity to satisfy today's questions risks undermining confidence in tomorrow's answers. Sit with that phrasing for a second, because it matters more than it sounds like it should. She isn't saying there's nothing to protect. She's saying there's something worth protecting, something specific enough that she's choosing not to release it yet, on legal advice, under a process designed for exactly this kind of restraint. That's a meaningfully different message than silence born of having nothing to report. Here's the part of this that actually matters legally, the part that turns a vague sense of unease into something you can actually reason through. A Mississippi district attorney has the authority to review a completed state autopsy, determine there's no evidence of foul play, issue a public statement, and close the file. That's it. That's the entire process for an ordinary accidental death with no suspicious circumstances attached to it. She doesn't need a grand jury for that. She doesn't need to seal anything. She doesn't need to order every investigator across 3 agencies to go silent and stay silent for weeks on end. If this were a straightforward drowning, she could say so this afternoon, hand this family the closure they've been begging for since July, and move on to the next case sitting on her docket. She didn't do any of that, and every one of those choices was hers to make differently if the evidence pointed somewhere simpler. She sealed the autopsy. She silenced every investigator attached to this case. She convened a grand jury, a step reserved specifically for deaths considered unnatural or suspicious enough to require a formal, independent legal determination beyond her own office's judgment. And the specific language she chose, that every piece of evidence must be examined, that every credible lead must be followed to its conclusion, that every witness account must be weighed against everything else gathered, is not the language of a prosecutor closing a file on a tragic accident. It's the language of someone actively building a case toward something, carefully, methodically, and with an eye toward whatever comes after the grand jury itself. Former Mississippi Judge Carlos Moore has been making a version of this argument for weeks now, and he isn't hedging. This isn't an armchair analyst speculating from outside the system. This is a man who spent his career operating inside exactly this kind of proceeding, who knows precisely what a grand jury is built to do and what it looks like when one is being used for something else. His central argument is this: you do not need an indictment to make an arrest. The evidence already sitting in plain public view, in his assessment, should have been enough to get someone in front of a judge for probable cause well before now. It's worth being precise here, because arrest and indictment get treated as interchangeable online, and they are not the same legal threshold at all. A grand jury indictment requires enough evidence to formally charge someone with a crime. That's a genuinely high bar, the kind that's meant to survive a trial. An arrest requires something much lower: probable cause, meaning reasonable grounds to believe a specific person may have committed an offense. You bring someone in on that standard. You question them under conditions that carry real legal weight, not the informal, voluntary conversations that have defined this case so far. You apply pressure a voluntary interview never can, and people tend to behave very differently once they understand they're not simply helping investigators piece together a timeline. You either build toward charges from there, or you clear them and move on with a cleaner case than you started with. Judge Moore's position is that the public evidence already clears that lower bar several times over, not once, not barely, but repeatedly. Start with the GPS data pulled from the boat itself. It shows exactly where that vessel went, when it stopped moving, how long it sat in specific locations before moving again, all of it time-stamped and independent of anyone's memory or willingness to tell the truth. If that timeline contradicts what the friends on board told investigators about where they were and when, in even one specific detail, that gap by itself is the kind of documented inconsistency that supports probable cause on its own, before anything else is even considered. Then there's the phone, whose hands it actually passed through in the hours after Nolan disappeared, where it eventually turned up, what it does or doesn't still contain, all of it still unresolved months into this, still sitting exactly where a proper forensic extraction was supposed to have already answered it. Then there's a detail that is specific enough and strange enough that it deserves its own moment rather than getting folded into a list. Nolan's father reportedly had to formally identify his son's body just to retrieve a set of keys. That process took 15 minutes. Keys to what? Why would returning a family's own property require anything resembling an identification procedure at all, unless something about that handoff wasn't simple, wasn't routine, wasn't the kind of thing you'd expect between grieving families and investigators who have nothing to hide from them? And then there's the 13-hour gap between Nolan going missing and the Coast Guard being formally requested to search for him. 13 hours. What filled them? Who knew he was missing during that window? And who said nothing while it passed? Judge Moore's assessment of all of this together, stacked up rather than considered piece by piece, is blunt, almost folksy in its plainness. Something here isn't clean. So if a former judge is saying the legal bar for an arrest has already been cleared, the obvious question is why hasn't one happened? There are a few real possibilities worth weighing honestly rather than picking the most dramatic one. The DA may want considerably more than bare probable cause. She may want an indictment strong enough to actually survive trial and produce a conviction, not an arrest that generates a news cycle and then collapses under its own weight in court once a defense attorney starts picking apart a rushed case. A grand jury also gives her something an arrest alone doesn't: the power to compel sworn testimony from witnesses who might otherwise never cooperate voluntarily, which is real leverage in a case built on conflicting accounts that don't line up with each other. Or, and this is the possibility Moore's own framing leans toward, she believes she's already sitting on something significant, and she's not willing to risk it by moving early, tipping off exactly the people she needs to stay unaware they're being looked at while evidence is still being gathered. Prosecutors generally get one real opportunity to bring a case. Move too soon, before the evidence is locked down, and you can lose the whole thing permanently. Watch a suspect destroy what's left of a digital trail, or coordinate a story with co-defendants before they're ever separated and questioned individually. Whatever her actual reasoning, the DA and Judge Moore agree on one underlying fact, even while disagreeing on strategy. There's enough here to keep building on. Now place Governor Tate Reeves directly next to that, because the contrast between these two men tells its own story. After everything that has already surfaced publicly, the GPS discrepancies, a recovered phone with unresolved location data, a 13-hour delay before help was formally called, an independent autopsy that still hasn't produced a determined cause of death, a $125,000 reward posted jointly by Al Sharpton, Tyler Perry, and Terrell Owens, a formal NAACP resolution demanding a full Department of Justice review. Reeves has said publicly that he personally has not seen a single fact or piece of evidence suggesting foul play. To be fair, it's possible he meant that narrowly, strictly limited to whatever has been made officially public through law enforcement channels rather than everything reported around this case. That's a real, if narrow, reading, and it deserves to be considered rather than dismissed. But he didn't frame it as we're still waiting on toxicology, or the investigation needs to run its full course before anyone draws conclusions. He framed it closer to a settled conclusion than an open question. Same state, same publicly available evidence. Two entirely different reads. A sitting governor who says there's nothing there, and a former judge with no political office left to protect who says an arrest should have already happened. That gap isn't simply a difference of opinion between two reasonable people. It's worth remembering that one of those two men currently holds elected office in a state already facing national scrutiny over exactly this kind of case. And that fact alone doesn't make him wrong, but it's not irrelevant either. Underneath every procedural detail in this update, there's a family living inside all of it in real time, not reading legal analysis from a comfortable distance the way the rest of us are. Christine and Elmore are the ones who haven't been allowed to see the autopsy report on their own son, sealed from the two people who arguably need to see it most. They're the ones who went through a 15-minute identification process just to get a set of car keys back, a detail that would be almost absurd if it weren't so clearly painful. They're the ones absorbing a level of public scrutiny, GoFundMe criticism, accusations about their parenting, questions about their motives, that almost no grieving parent should have to carry alongside not knowing what actually happened to their child. Every week this grand jury process stretches on is another week that weight doesn't lift for them. Whatever this grand jury eventually decides, that particular burden doesn't ease until there's an actual answer, not a procedural update, not a sealed document, an answer they can finally hold on to. What we do know for certain isn't in dispute anywhere, regardless of which side of the Reeves-Moore divide you land on. The FBI has confirmed its own involvement, specifically investigating interstate threats made against people connected to this case, threats serious enough to cross state lines and become a federal matter entirely separate from the question of how Nolan died. That's not a small detail to gloss over. It means people tied to this story, witnesses, family members, possibly investigators themselves, are being threatened seriously enough that federal law enforcement had to step in on that basis alone. That tells you something real about the temperature surrounding everyone who has information here right now. And it's worth remembering the next time someone online treats this case as a quiet local matter that's simply been overblown by attention. The NAACP has passed a formal resolution calling for a complete Department of Justice review, the kind of institutional weight that simply doesn't attach itself to a case the federal government considers routine or already resolved. Organizations with that kind of national reach don't formally request DOJ involvement lightly or on a whim. And that $125,000 reward isn't sitting there for help piecing together a general timeline of who was where. Sharpton has been explicit that it's specifically for information leading directly to an arrest and a conviction, not simply a tip that helps reporters fill in gaps, and that this effort doesn't end at the funeral or fade quietly once the cameras move on to the next story. Tyler Perry personally covered the cost of that funeral and then matched the reward fund on top of it. That is not a community sitting in quiet uncertainty. That's a community making a specific resource demand and backing it with legal pressure and a platform that makes this case very difficult to simply let fade. Here's something worth understanding plainly, because a lot of the public conversation around this case assumes the only two possible outcomes are a murder charge or nothing at all, and that framing is simply wrong. Tampering with evidence, failure to report a death, obstruction of justice. None of those charges require proving what actually caused Nolan to die. They require proving what happened after, what was done with his phone, what was done with his keys, what was said, or deliberately left unsaid, in those 13 hours before his mother reported him missing. If someone moved or concealed evidence, if someone withheld what they knew when they knew it, if separate accounts were quietly coordinated rather than given independently and honestly, those are prosecutable on their own terms. under a meaningfully lower burden of proof than establishing that a death was caused deliberately by another person's hands. That distinction matters enormously for understanding what a grand jury indictment here could actually look like, even in a scenario where the underlying cause of death itself ultimately remains officially undetermined or gets ruled accidental. A case doesn't have to prove murder to hold someone legally accountable for what they did once Nolan was already gone. When this grand jury finally convenes, a panel of ordinary Mississippi citizens, people with no stake in this case beyond their civic duty, will see the autopsy report that Nolan's own parents still haven't been allowed to see. They'll hear sworn testimony from people who have so far only spoken through attorneys, through carefully worded statements, or through anonymous accounts filtered secondhand through reporters. They'll review evidence that has been sealed from public view this entire time, evidence that has driven weeks of speculation precisely because nobody outside a small circle has actually seen it. And they will decide, formally and under oath themselves, whether what happened on that island and what happened in the hours and days after rises to the level of criminal accountability. That moment hasn't arrived yet. But every choice the DA made on July 23rd, silencing her own investigators, sealing the evidence, choosing language built for a case still very much in motion rather than one being quietly wound down, points toward a prosecutor who believes that moment is still coming, whether it arrives through an arrest before the grand jury convenes or an indictment that comes directly out of it. So, pulling this together, a prosecutor who legally could have closed this case with 3 simple words chose instead to seal it, silence every agency attached to it, and send it to a grand jury, a path nobody takes for a case they consider finished. A former judge, speaking from inside the system rather than outside it, says the public evidence already justifies an arrest and points to specific, checkable facts, GPS data, a disputed phone, a 15-minute identification process for a set of keys, a 13-hour delay, to back that up rather than vague suspicion alone. A sitting governor, facing very different incentives than a former judge with nothing left to protect, says he sees nothing at all. The FBI is actively investigating threats serious enough to cross state lines. A reward now standing at $125,000, with a specific portion of that tied directly to an arrest and conviction rather than general information, is sitting on the table right now for anyone willing to come forward. And underneath every one of those threads, a family is still waiting, months into this, for the one thing none of this procedure has actually given them yet. An answer they can hold on to instead of another sealed document or another carefully worded statement. This case is not closed. The investigation can't formally conclude until toxicology results return from both the state autopsy and the independent one the family commissioned, and both remain outstanding as of tonight, weeks after they were first expected. Every additional week of that wait is another week this family spends without the one thing they've asked for consistently since the very beginning. Not a theory, not a procedural update, just the truth about what happened to their son. We're going to stay on this story as that grand jury moves, as those results finally come back, and as this case heads toward whatever comes next. If this is the kind of reporting you want, sourced, verified, nothing added for shock value, subscribe. We'll bring you the facts as we actually get them, and not a moment before.